Acknowledgement of order item number 1. I have discussed the law and the facts, so I'll not read out the whole judgment. In view of the above, this petition is hereby allowed. The accused petitioner is directed to be released on bail if not wanted in any other case on the following conditions. Conditions are set out. Petition disposed of. Any mention?
Yes, Your Honour. Oh, yes, Your Lordship. I beg to mention item number 4, Your Lordship.
Why?
I pray for 2 weeks' time, Your Lordship, since my seniors.
How many times have you asked for time in this case?
Must be quite a lot of time, my lord. They have been praying time, but my lord, in between there were change of council also. So they have been the earlier council recused and new council came, because it happens to be like their clients has taken up the office. So there were some senior council was representing at the initial stage. So subsequently they withdraw from the case and they entered into appearance. So there was also a long delay in that way, my lord.
How long?
2 weeks, Your Lordship.
On pre-made by Ms. and counsel of the petitioner, that is adjourned. This matter up to 2 weeks.
Obliged.
Item number 1.
Connected to
That's correspondent number 4. Mr. Counsel for the respondent number 4 to 6 has sought for some more time to file the counter affidavit. The same not be objected. I have not objected to by the petitioner. That is adjourned. This is after 2 weeks.
interim order is there, my lord.
In the meantime, the interim order will remain in force until further orders.
Obliged.
Please, Lordship.
Yes.
This matter, Lordship, is the question of law similar to the previous matter. The hearing and
In fact, analogous matters. Number 1 and this item, number 2.
Analogous in the sense the
subject matters.
Subject matters.
emanate from the same
Yes.
impure order,
No,
Different orders.
But the decision in
similar nature.
Yes. No, my lord, in the last occasion I had raised the issue. I said that an appeal would lie to the executive committee. And then they wanted to file a reply on that point. Because, my lord, the act says you want some time? Okay, take some time then. Any order passed by the tribunal is subject to that issue, my lord.
Okay, okay. The appellate
Yes,
authority.
So here it is the matter of limitation of filing of the election petition.
Okay.
So my contention is that even then, the issue ought to approach the executive committee first.
That could have been, that could have been decided at the
Yes.
at the earliest.
Anyway, since they're praying for time, let's
Lordship, kindly announce.
Mr. Counsel, for the petitioner has sought for accommodation on what ground?
Lordship, just required to a hearing for another 2 weeks, Lordship. Can you allow?
What is your ground for?
The conducting counsel is also not here, Lordship, Mr. J. Shilla.
Mr. Shilla.
On the ground that the conducting counsel, Mr. Jeshila, is indisposed. Pray aloud, as prayed for. Pray aloud. As prayed for, this is married 2 weeks.
Item number 3.
May it please, Your Lordship. This is an appeal which has been directed against the impugn order, judgment and order dated 14/7/2023, my lord, passed by the special judicial officer, whereby the claimant was awarded compensation of rupees 22,51,600, my lord. Along with, in addition to that, 30% of solicium and the enhanced amount was allowed with an interest of 12% with effect from the date of publication of the notification under Section 4(1) of the Land Acquisition Act of 1894.
Yes.
Till the date of award and taking possession of the land, whichever is earlier, my lord. The appellant has approached this honorable court against this impugn order, my lord.
Your for respondent number?
I am respondent number 1 and 2, my lord. My lord, the grounds which the appeal has been preferred, my lord, will, if your lordship kindly take the appeal, my lord, memo of appeal, my lord, at page 15, my lord. Page 15 of the memo of appeal, my lord.
Yes.
Number 1, my lord. Further, the learned reference court committed an error in entertaining the reference application dated 18/8/2006 preferred under Section 18 of LA Act and entertaining the reference case which was filed after a lapse of 13 years from the day of the award dated 18/11/1993 passed by the collector. Though not admitted, but assuming that the time spent in the litigation can be excluded, still the reference application dated 18/8/2006 submitted by the respondent number 1 and 2 to the collector East Khas Hills after more than 3 years, my lord, from the date of the judgment and order dated 25/8/2003 passed by the Honorable Division Bench of the erstwhile Gaudiya High Court. My lord, I'll just refer the brief fact of the case, my lord. What happened is that in this particular case, my lord, notification under Section 4A of the 4 of the LA Act, my lord, was issued on 30/6/1987, my lord, for acquisition of a land of 480 square meter, roughly around 5160 square meter, my lord. Declaration under Section 6 was made on 14/1/1988, my lord. Thereafter, my lord, we had the respondent had approached the then Gaudiya High Court, my lord, and by judgment and order dated 26/11/1991, the area was reduced from 5160 to 3000 square feet, my lord. So corrigendum was issued by the collector in this regard on 23/12/1991. The area was declared for 3000. The acquisition area was declared as per the High Court order to 3000 square feet, my lord. Declaration was made under Section 6 on 4/1/1993, my lord. My lord, against the corrigendum and the declaration under Section 6, I have again approached the Honorable High Court, my lord, While order dated, judgment on order dated 23/8/1993, both the corrigendum and the declaration under section 6 was set aside, my lord. Thereafter, my lord, declaration under section 6 was issued on 17/9/1993, my lord. That your lordship will find my lord, will kindly come to page 35, my lord. of the paper book, my lord.
35.
Paper book, my lord.
Yes.
Page 35 of the paper book, my lord. If your lordship kindly says declaration 17 September 1993, my lord. This is another section 6. My lord, kindly keep in mind that the section 4 notification, which was earlier issued in 1987, and the declaration under section 6, by way of the judgment and order dated 26/11/1991, that area was reduced to 3,000 square feet, my lord. On the basis of that, corrigendum was issued, my lord, whereby rectification was made with regard to the area which is under acquisition, my lord, from 5,160 square feet to 3,000 square feet, my lord. So subsequently, on the basis of the judgment order, both the corrigendum and the declaration under section 6 was set aside by the judgment dated 23rd August 1993, my lord. Subsequent thereto, my lord, this declaration was issued by the collector, my lord. If I may read, my lord.
What was wrong with the previous declaration?
My lord, we have challenged it, the declaration under the corrigendum and the declaration under 4/1/1993, my lord.
Why?
Because, my lord, the survey was not conducted at that point of time. Survey was not conducted. Subsequently, even in spite of the order of the High Court, my lord, then subsequently the survey was conducted and the declaration was made on 17/9/1993, which is, my lord, this declaration dated 17 September 1993, which is at page 35. Whereas the government of Meghalaya is satisfied that the land at Police Bazaar, Shillong, in East Kharsail district, more fully described below, is needed for public purpose, namely for the construction of Shillong Cooperative Urban Bank Limited building. And whereas the Honorable High Court directed fresh notification to be published of the earlier government notification dated so and so, 4 January 1993, in terms of the judgment and order dated 23rd August 1993, my lord, in civil rule number so and so and so, relating to the acquisition of the land, my lord. Now, therefore, it is hereby declared that the land measuring more or less 3,000 square feet or 278 square meter and bounded as follow, so and so, so and so, is required for public for the purpose of aforesaid, my lord. A map of the plot of land may be inspected in the office so and so. So, my lord, this is the final declaration after the litigation which was carried out between the parties. This is the final notification in as far as the acquisition is concerned, my lord. This has been arrived at on the basis of the judgment and order which has been passed by the Guwahati High Court, my lord. On the basis of that, my lord. Thereafter, because the point which they have issued as far as the delay is concerned, because they are saying that there is a delay of 3 years in preferring the my lord, the application for under section 18. That's their contention, my lord.
Delay on the part of the collector to refer the matter, or delay on your part to file the application?
My part on the filing of the application with regard for enhancement under section 18, my lord. My lord, to that effect, my lord, I would like to take your lordship that page 42, if your lordship kindly come to page 42, my lord, the paper book, my lord. This is the award, page 42, your lordship, form 18, my lord. To Sri Sant Kumar Bajoria and Sri Sundar Kumar Bajoria, my lord. These were the owner, my lord.
Yes.
Notice is hereby given that in view that in the above case in which you have been treated as person interested, an award made by me on 18/11/1993 under section 2 of the Act 1 of 1894, the payable amount, the sum payable to you is rupees 3,98,400 only. If you are willing to accept payment, you should appear before me personally on 18/8/2006 at 11 a.m. Interest will not be payable in case of failure to appear, my lord. My lord, this is the award which has been given to me, my lord. And your lordship will see on the right hand side on the date is 4th August 2006, my lord.
Yes.
Your lordship will come to the next page, 43. Immediately, my lord, I have filed an application for referring the matter to the Special Judicial Officer under section 18, my lord. So the award was
Yes.
taken by me under protest, my lord. This is my application under protest and a request
Yes.
for referring the matter to the Special Judicial Officer under section 18 for enhancement, because I was aggrieved with the rate which has been given by the government, my lord.
Yes.
My lord, will kindly come to the next page, 44, my lord. Award was made on 4th August 2006. I was asked to appear on 18/8/2006. If your lordship kindly would kindly see again on page 42, my lord.
Yes.
Your lordship must have seen that. If you are willing to accept the payment, you should appear before me personally on 18/8/2006, my lord. I had appeared on 18/8/2006. I have taken the award under protest. This is my application for referring the matter under section 18, my lord. Your lordship will see this was filed on 18/8/2006, my lord. So there is no delay as claimed by the appellant, my lord. So that is my first point in as far as delay is concerned, my lord. This is the ground which I have taken, that there has been a delay for filing of the application under section 18. So in my respectful submission, my lord, there is no delay whatsoever in as far as section 18 is concerned, which has been filed by me on the same date when I was asked to appear before the collector for collection of the award which has been awarded to me, my lord. So the second point, my lord, your lordship, one more fact I would like to draw to your lordship. My lord, what had happened is that why there was a delay, because here if your lordship sees that the award was made on 18/11/1993, my lord. The notification has come up only in 2006, my lord. In between, my lord, what had happened is that the collector has made the award on 18/11/1993. At that point of time also, my lord, I have filed an application under section 18. That was rejected, my lord. That was rejected on the ground that, by the collector, on the ground that I should pay ad valorem court fee on the award so that I will be able to file the application under section 18, my lord. Against that order also I have approached the Honorable High Court at that point of time. On the basis of that, my lord, my application was allowed, and the collector was directed to take into consideration my application under section 18, my lord. Against that also a writ appeal was filed by the appellant, my lord. That was dismissed, and the judgment and order of the single bench, whereby it was directed, where the collector was directed by the government. The government has filed the appeal, my lord, against the order. That order was challenged by the government of Meghalaya on the ground of the ad valorem court fee, my lord. That was dismissed, and the order of the single judge was upheld, my lord. So on the basis of that, direction was given to the collector that he should accept the application under section 18 of the respondent. In view of that, my lord, this notification was issued thereafter, my lord.
In August.
That, my lord, that judgment and order is was passed only on 25th August 2003, my lord.
But by this court.
By this court, my lord. The division bench, my lord. Single bench has against the order of the collector, whereby I was asked to pay an ad valorem court fee on the award, which the collector has rejected my application under section 18. I had approached the single bench. That was the single bench has allowed my writ petition, saying that he should accept my application under section 18, because law does not provide that for filing an application under section 18, ad valorem court fee has to be paid, my lord. So against that decision, my lord, they had approached the division bench, my lord, the government, my lord. That writ appeal was dismissed, and the division bench also has upheld that there's no requirement for paying of ad valorem court fee in as far as section 18 application for section 18 is concerned, my lord. On the basis of that, my lord, this award was given only on 4th August 2006, my lord, whereby I was asked to appear on 18/8, and accordingly on 18/8 I had appeared, filed my application under section 18, my lord. So that there was no delay as such as alleged by the appellant, my lord. So the first ground of this appeal of delay, my lord, your lordship, I think I've made it clear that there's no delay as such as alleged by the appellant, my lord. The second part, my lord, is that second ground which they have taken in this appeal is that, if your lordship come to page 16 of the memo of appeal, my lord. My lord. My lord, just one more fact, my lord. In as far as your lordship will find the dates where my application under section 18 was rejected by the collector, my lord. That your lordship will find at page 9, paragraph 10, my lord. I'll just read it out, my lord. Your lordship kindly come in the memo of appeal, page 9, paragraph 10, my lord. Memo of appeal, my lord.
Yes.
Paragraph 10, my lord, page 9. That the present respondent number 1 and 2, being aggrieved with the award for a sum of rupees so and so, passed by the pro forma respondent collector so and so, submitted application dated 4/3/1993, my lord, under section 18, for a reference before the appropriate special judicial officer for enhancement of the amount of compensation.
Yes.
Upon rejection of the same by the pro forma respondent collector by order dated 21/5/1996 and 26/1996, the respondent number 1 and 2 had filed a writ petition before the Honorable High Court, which was allowed by the learned single bench, white order dated 12/5/1997, my lord. And the writ appeal of 1991 filed by the state government, well, against this writ petition, my lord, which was allowed, an appeal was filed by the state government, my lord. That was registered as writ appeal number 32 SH of 1991. Filed by the state government was also dismissed by the learned division bench by judgment and order dated so and so, by holding that filing of application under section 18 of LA Act does not require payment of ad valorem court fee by the claimant, and further directed the collector to proceed with the case as directed by the learned single judge, my lord.
Yes.
The judgment, my lord, of the division bench, my lord, that your lordship will find at page 38 to 41 of the paper book, my lord. 25th August 2003, my lord. 38 to 41, my lord. Should I read it out, my lord? It's not required, my lord. Because this is an admitted fact, my lord. It's not required, my lord.
I think there's no No quarrel.
There's no dispute, my lord. There's no dispute. So page 38 to 41 is the judgment of the division bench, my lord, whereby direction was given to the collector to accept the application under section 18. So that's why, my lord, the award was made only on 4th of August 2006, my lord, by the collector, whereby I was asked to appear on 18th of August. I had appeared on that same date, received the award, filed my application under section 18 of the LA Act, old LA Act, my lord. So there is no delay as such as has been alleged by the appellant, my lord. The second, my lord, the second ground, if your lordship come at page 16, my lord. I'm sorry, my lord, we have to correlate with the memo of appeal and the paper book, my lord. Page 16, my lord. This is the second ground, my lord.
Yes.
Further, the learned reference court committed an error in arriving to a finding that the relevant date for computing the period for the purpose of determining the market value of the land should be reckoned from the corrigendum notification dated so and so 23/12/1921 in pursuant to the judgment and order dated 26/11/1991 passed by the Honorable Division Bench in Civil Rule number 88 SH of 1988 as well as Civil Rule number 129 of 1988 filed by the respondent number 2. The prime reason being that the aforesaid corrigendum notification dated 23/12/1991 was non-existent, since the same along with the modified declaration issued under section 6 of the LA Act was set aside by the Honorable Division Bench of the Guwahati High Court by judgment and order dated 23/8/1993 passed in Civil Rule number 167 of 1993, and above all section 4 was issued on 30/6/1987 and not on 23/12/1991. Hence, reliance on the date was no longer relevant, is not tenable in law, my lord. So basically, my lord, if your lordship kindly come to, this is a judgment, my lord.
Yes.
If your lordship kindly come to page 284 of the paper book, my lord. That is what the appellant is referring to, my lord.
284.
284, my lord.
Paper book.
Of the paper book, lordship.
What dated
Your lordship.
1811?
Your lordship. Notice under, your lordship comes to the last paragraph. Notice under section 4. Notice under section 4 was issued by the government of Meghalaya by notification dated 30/6/1987, which was published in Meghalaya Gazette on 23rd July 1987, stating that more or less 480 square meter of land in police preserve with the boundaries described in the notification was to be alienated for public purpose, namely for construction of Shillong Cooperative Urban Bank. However, by a later corrigendum, the amount of land sought to acquire was refixed at 3,000 square feet. Subsequently, a declaration number so and so dated 23/12/1991 was issued and published in Meghalaya Gazette Extraordinary dated 23/12/1991 for the purpose. Therefore, the relevant date for computing the market value of the land should be reckoned from 23/12/1991 when corrigendum was issued in this regard. The sale deed at exhibit so and so. So, my lord, the special judicial officer, my lord, has placed reliance in as far as the computing of the market value of the land on the basis of the notification dated 23/12/1991. Their contention is that, my lord, the special judicial officer, the award which has been given to me is erroneous, because this particular declaration has been set aside by the Honorable High Court, my lord. My lord, in my respectful submission, my lord, the special judicial officer should have taken the date of reckon in as far as the valuation of land is concerned should have been, my lord, at which I have indicated earlier, my lord, should have been from 17 September 1993, my lord.
Yes.
Why I'm saying so, my lord?
Yes.
This notification
Yes.
issued by the collector, my lord,
Yes.
have superseded
Yes.
all the earlier notification, my lord. This is the final notification, my lord, in my respectful submission, my lord. So the date should have been 17 September 1993, my lord, not as has been stated 23/12/1991, my lord. This is the final notification, my lord. All the other notification which was issued by the collector has been superseded by virtue of this notification dated 17 September 1993, my lord.
No, the in the earlier notification,
My lord.
The rate is different. The rate is different, or
No,
same?
not the rate, my lord. My lord, what this is the rate, my lord. Why because the special
Because this will have a correlation with the rate.
my lord, the special duty officer have taken the notification of 23/12/1991 as the date to compute the rate of the land. That means the market value of the
value
land,
and
my lord.
whatever.
My lord. So, my lord, the special duty officer have taken into consideration the notification under section 4 of 23/12/1991. My lord, in my respectful submission, that notification has already been set aside by the Honorable High Court, my lord. That is not disputed, my lord. But, my lord, the ultimate and final notification on the basis of all the judgment and order which has been passed by the Honorable High Court, that has culminated in the issuance of this notification or declaration dated 17 September 1993, my lord. This is the final. Your lordship will see the wording, my lord. Page 35, if your lordship see.
35 of the
35 of the paper book, my lord. So all other notification which has been issued earlier has become redundant, my lord. That is what the law prescribes, my lord. It's a settled law, my lord. Well, Declaration 17 September 1993. Whereas the government of Meghalaya is satisfied that the land at Police Bazaar, Shillong, in East Kharsail district, more fully described below, is needed for a public purpose, namely for the construction of Shillong Cooperative Urban Bank Limited building.
Yes.
And whereas the Honorable High Court directed fresh notification to be published in the earlier government notification dated so and so, dated notification number so and so, dated 4 January 1993, in terms of its judgment and order dated 23rd August 1993 in civil rule number so and so relating to the acquisition of the land.
Yes, so this notification will supersede all earlier
other notification earlier.
notification in this regard.
My lord. So this will be the ultimate notification whereby the special judicial officer should have taken consideration, because 23/12/1991, where the special judicial officer has placed reliance in as far as for computing the market value at that point of time, my lord, this notification has already been set aside by the Honorable High Court, my lord.
This is notification under section 4.
Section 4, my lord. So, my lord, all notification, my lord, the initial, I'll just refresh your lordship.
So what I think I can understand.
My lord.
What you are trying to say is that all earlier processes
My lord.
taken up by the collector or any authority for that matter stood dissolved by the
Have become redundant.
by passing of the relevant judgment of the High Court.
Your lordship.
Subsequently, after all is said and done, fresh notification has been issued.
Issued, my lord.
This notification under of 1993.
Your lordship. 17.
So therefore, the value of land should be calculated as on that day.
Your lordship. as on 17 September 1993 and not 23rd December 1991. This notification has already been set aside by the, so all the notification which has been passed earlier has culminated in the notification, the declaration dated 17 September 1993. All the other earlier notification have been superseded, has become redundant. My lord, that, Your Lordship, is a settled law. My lord. Your Lordship, I would like to place one judgment of the Apex Court in this regard, my lord. This has been reported in 2013, volume 14, SCC 195. My lord, the head note, I'll come to the paragraph subsequently. The head note which has been A, head note A, my lord. Section 4, 6 and 18. Successive notification or declaration, effect of, reference on basis of superseded notification, impermissibility of health. Issuance of successive notification or declaration would supersede the entire the earlier notification or declaration. It would not be permissible for either party to make reference to superseded notification or declaration. General Clauses Act 1987 under section 21. So, my lord, the relevant paragraph, my lord, will be paragraph 9 to 11, my lord. Paragraph 9.
Yes.
There cannot be any dispute to the settled legal proposition that successive notification under section 4 or successive declaration under section 6 of the Act can be made. However, the effect of the same would be that earlier notification declaration stands obliterated, superseded, and in such a fact situation, it would not be permissible for either of the parties to make any reference to the said notification declaration which stood superseded, my lord. Paragraph, my lord. In Bhutnath Chatterjee versus State of Bengal, West Bengal, this court held that where section 4 notification has been issued, the market value is to be determined in terms of the later notification for the reason that there was an intention to supersede the previous notification, and if the government did not choose to explain the reason which persuaded it to issue the second notification, the court is justified in interfering that it was intended to supersede the earlier notification by the later notification. In Land Acquisition Officer versus Ramchandra Reddy, while dealing with the same issue, this court held, paragraph 16, the government, after considering the fact and circumstances with a view to avoid further challenge, issued a fresh notification dated 9/9/1993, followed by final declaration 16/12/94. The state government did not subsequently cancel, resign, withdraw the notification 9/9/93 and 16/2/1994. The state government had clearly abandoned the earlier notification dated 3/1/90 and 10/1/90 by issuing subsequent notification dated 9/9/93 and 16/2/1994. The appellant cannot therefore contend that the second preliminary notification is redundant or that the first preliminary notification continues to hold good. So, my lord, as per the Apex Court, my lord, it is very clear that any subsequent notification which has been issued, the earlier notification will become redundant, my lord. So, in this particular case, my lord, as I have pointed out, the notification declaration dated 17 September 1993 will hold a field, my lord. So, the date for computing the market value would be from 17 September 1993 and not 23/12/1993. My lord, the contention of the appellant is that since the notification under section 4 was issued on 30th June 1987, so the date for computing would be as on 36/1987. As I pointed out, and as the citation which has been cited by me, my lord. The apex court has clearly stated that it is a settled law that any notification which has been passed earlier and subsequent thereof, my lord, the earlier notification whichever has been passed would become redundant, my lord. The notification which has been passed subsequently would hold the field, my lord. So, my lord, the second aspect, as far as the stand of the ground which has been taken up by the appellant itself, my lord, it will be very clear that the computation cannot be done on the basis of notification under section 4, which was published on 30/6/1987, my lord, because all those notifications have been superseded by the declaration dated 17 September 1993. It's not because of the notification which has been issued by the collector, my lord, because this has been done so in view of the fact that the parties has approached the Honorable High Court, wherever the Honorable High Court has set aside all the earlier notification. My lord, there was no notification which is under existence. Only notification which is under existence after the parties, contesting parties, has approached the High Court is the notification dated 17 September 1993, my lord. My lord, the third ground which has been taken by the appellant, my lord, that you also will find at page 17. Page 17 of the memo of appeal, my lord. Yes.
Yes.
The third ground, my lord. Further, the learned reference court committed an error for relying on registered sale deed dated 31/12/1991 for determining the market value of 3,000 square feet at the rate of 800 rupees, for the simple reason that the opposite sale deed dated so and so was administratively registered 4 years from the date of section 4. Well, your lordship will see that they are still referring to section 4, my lord, that is 1987. That's why they are saying that this particular sale deed was registered 4 years after, my lord. As I've stated earlier, my lord, in my respectful submission, my lord, the earlier notification has become redundant, my lord. This has been superseded by the declaration dated 17 September 1993, my lord. Relied on still the said land measuring so and so square feet, the total area of total price was 5 lakh, was at the rate of 595 per square feet and not 800 in the prevailing at 1991. Moreover, the total cost of so and so was combined cost price of so and so and the shop house standing there. Admittedly, the claimant respondent number 2 or 3 failed to adduce any evidence as to the cost of the shop and house standing there, whereas the sale deed dated 12/7/1988 as Exhibit A, selling of plot situated at Plus Bazaar, was mentioned rupees 15. Sale deed 27/10. These are all the exhibited which has been exhibited by them alone. Sale deed dated 27/10/1989 as Exhibit B, selling of plot with 2-storied RCC building situated at Plus Bazaar, the rate of rupees 383 per square feet, as well as sale deed dated 1/3/1988 Exhibit D, selling of plot with the 3 houses situated at Anup Shan Lane, Plus Bazaar, the rate of rupees 204 per square feet has been noticed by the learned reference court. Hence, despite of the above, the reference court enhance enhancing rupees 800 rupees per square feet, which is more than 10 times of the 80 per square feet determined by the collector, is highly unreasonable, arbitrary, and illegal. My lord, I would like to take your lordship. What was the rate which was given to me, my lord, or the assessment which was done by the collector, my lord? My lord, your lordship, as your lordship is aware now, that the total area which has been acquired is 3,000 square feet, my lord. The amount in respect of the land which was given to me, your lordship, was rupees my lord, I have taken this certified copy from this honorable court only, my lord, because this was not with me. This is the award statement, my lord, by the collector itself, my lord.
It's not in the paperwork.
No, it's not there also in the paper book, my lord. It's there on the records, my lord. It's there on record. I've made if you like, my lord. This is the award which was initial award, my lord. Initial award, my lord.
No, earlier you were reading that award.
My lord, that this is the first award which was this was the first award, my lord. This was the first award, 1992. Subsequently, my lord, after, because what had happened, so there was court cases up and down. Subsequently, because the report was not prepared, then the High Court has ordered for preparation of the report.
Yes.
Then the award of 2000, the page 34, my lord, the award was issued subsequently, my lord, which I pointed out, my lord. Your lordship will kindly see
Yes.
the amount which was given
This
to me.
this award is dated.
There's no date. This is 1992. If your lordship see the last page is 1992, my lord. There's no date has been put in, my lord. Right down below, my lord. Dated Shillong, 1992. No date whatsoever has been put, my lord. This is the assessment, my lord. So 2,40,000 was paid to me, my lord, for the land. If your lordship kindly see. At column number 7, my lord. First page,
Yes,
column
yes.
7. Amount allowed for the land itself without trees, crops, building, etc., etc. 2,40,000, my 2,40,000, my lord.
Yes.
Well, this is part of the record because this was filed by the collector. This was so my lord, 2,40,000 was paid to me for 3,000 square feet, my lord. Which means, like, my lord, it comes to 80 rupees per square feet, my lord. Land which was given to me, my lord. This is, your lordship is well aware. This is, my lord, on the GS Road, Police Bazaar, where the bank is situated, my lord. My lord, this is a commercial area, my lord, where and it's commercial plus normal area, my lord. 80 rupees, my lord. Even
Hey, whatever the case may be, see,
Hello.
that is an issue that to be decided by the reference court.
that has been decided also.
So against this, you have preferred, Section 18
My lord.
application.
Your lordship. So 800 was awarded to me. I'm just pointing out, my lord. At that point of time, the assessment was made at 80 rupees a square feet, my lord. So the after the section 18 was preferred, the court has awarded me 800 rupees per square feet, my lord. So, my lord, coming back to the ground 3 which has been taken, my lord, because the reliance has been placed by the trial court in coming to a finding of rupees 800 per square feet is on the basis of the sale deed dated 31/12/1991, which is slightly adjacent to the hardly maybe 30 meters or 40 meters. This is that very famous restaurant in Shillong, my lord. This is belongs to Mr. Wong. It's just nearby, just 30-40 meters from that. So this is the sale deed of that particular restaurant, my lord. So it's really 30 meters, 20 to 30 meters from the land which has been acquired, my lord. So the sale deed at that point of time, my lord, was executed in 1991. So at that point also, my lord, the price was the rate which was after calculation. This is a registered sale deed, my lord. It's 598 per square feet, my lord. But that is the nearest which we have found out, my lord. So this is 1991, my lord. So if we go by the notification dated 17 September 1993, in my respectful submission, my lord, the award of 800 rupees also is slightly below the market value, my lord. Should have been 1200 as demanded by us through. We have demanded 1200 rupees a square feet, my lord.
Any comparable sale deed?
This is the only comparable sale deed, my lord.
That
This was 1991, my lord.
500 plus.
Yes, my lord. This is almost 600, my lord.
Okay.
So this is the sale deed of 1991, my lord. So the declaration which the learned trial court or the special judicial officer should have taken into consideration is of 1993, my lord, and not of 1991, my lord.
But you see, I think before the reference court,
Your lordship,
what you should have do, I don't know, I have not gone through the records.
your lordship,
What you should have done is, as far as that 5,500 plus is concerned,
your lordship.
if you are saying that as in 1993 the amount should have been more,
Much more,
the value rather,
your lordship,
market price should have been more,
your lordship.
then there must have been there has to be some evidence, either documentary or otherwise, or ocular, where the issue of enhancement, the issue of appreciation of value and all things is taken to, that is not there.
No, it's not there, my lord. But what my submission is that, my lord, this sale deed is of 1991. The notification which should have been taken into consideration is 1993. But the special judicial officer have taken the notification dated 23/12/1991. So 91 it makes sense, my lord. But as I've stated earlier, that the earlier notification has also become redundant, my lord. So the date on which the competition should have been done should have been on September 1993, 17 September 1993. That means, my lord, 2 years after, my lord. So obviously, my lord, 2 years difference is there. So if I'm placing a sale date of 1991, so if the notification is taken into consideration for computation of 1993, so the value automatically will go higher. Hypothetically, my lord.
Exactly, that's what I'm saying. But there is
only thing is that
no evidence in that regard.
No, my lord. Only thing is that the only nearest sale date which has been placed reliance by me is of 1991, my lord. So what I'm submitting is, my lord, that taking into consideration that the special judicial officer have taken into consideration the notification dated 23/12/1991 for computing the value, the market value, my lord, at that point of time to be 800 rupees, my lord, is also faulty in the sense that, my lord, if the final culmination of all the declaration and notification would be of 1993, so that would be 2 years after that, after the sale date of 1991, my lord.
Even then, there would be your assertion,
My lord.
but nothing in evidence.
No, nothing in evidence, my lord, because this is the nearest sale date which I have been able to obtain is the sale date of 1991. My lord. So hypothetically, my lord, what I'm submitting is that, my lord, the learned court below has taken consideration of the 91 sale deed, whereas the notification for computing should have been on 1993. Hypothetically, my lord, taking that into consideration, 2 years. Even if it's 600, taking into consideration 600 in 1991, the value should have been more than 800 rupees, my lord. That is my only contention, my lord. But even then, the learned court below, taking into consideration the 1991 sale deed, has awarded the sum of rupees 800 per square feet for my land, my lord. So, my lord, the third submission, my lord, the third ground which have been taken by them, that sale deed the 1991 sale deed has been taken into consideration, my lord. There's nothing wrong in it, my lord, because the learned special judicial officer have taken cognizance of the notification dated 23/12/1991. That is 23rd December, whereas the sale deed was 31st December, my lord. Subsequent thereto, even not assuming, not taking into consideration the declaration, the final declaration of 1993 also, my lord. There's nothing wrong in that. In my respective submission, my lord, the 800 rupees which has awarded to me, since I have not led any evidence, my lord, it's just, my lord, it's justified, my lord. So, my lord, what they have done is that they have placed reliance on 4 exhibits which they have exhibited in the entire proceedings, my lord. Your lordship will kindly find, if your lordship kindly come to page 262, my lord. Page 262 of the paper book, my lord. This is judgment, my lord. (262). So down below, my lord, para 14. These are the issues. There were 5 issues which were framed by the court, my lord, below, my lord.
Yes.
So I have 5 issues were framed. I have got 6 witnesses, my lord, in support of my case.
Yes.
The pro forma respondent, that is the collector, did not examine any witness. The opposite party number 2 examined 2 witnesses, my lord. My lord, I don't know, in as far as they have the exhibits, your lordship will find at the page 264, para 18, my lord.
Yes.
So exhibit 1, 2, 3, 4, 5 was exhibited by me. Paper mark 1, 2 exhibited by me. Paragraph 19, my lord. The OP number 2 exhibited the following documents. Exhibit A is in regard to the sale of land at Jail Road for a sum of 45,000. B, dated so and so, in regard of sale of land at Police Bazaar for a sum of 15 lakhs. Then C, dated 2nd August 94, an area of 0.284 acre at 12,37,000. Then D, 1st March 88, certified registered sale deed in respect of so and so and so and so. So these are the exhibit which they have exhibited by the opposite part, by the appellant, my lord.
Yes.
My lord, interestingly, my lord, this exhibit, it has been mentioned here in the judgment, my lord.
Yes.
It has been mentioned as exhibit, my lord, whereas this document were never exhibited by the appellant, my lord, nor in the deposition by way of affidavit, both the witnesses, my lord, nor in the cross-examination, nor before the court, my lord. These were never exhibited by the appellant, my lord. So in view of that fact, my lord, whether this exhibit can be taken into consideration, my lord. My lord, I'll take to your lordship to the evidence which has been furnished by the evidence starts at OPW1, my lord. OPW1 starts at page 187 of the paper book, my lord.
OPW1 is the collector.
No, my lord, sorry, my lord. This is the opposite party, because collector has not examined any witnesses, my lord.
So this is
by the bank, by the appellant, my
the
lord.
appellant here.
Appellant here, my lord. So this is Mr. Brian Dermot Kharpran Dali. My lord, I have gone through the entire evidence, which by way of affidavit, my lord. There's no mention in as far as the exhibits are concerned, my lord. All the 4 exhibits, A, B, C, D.
Who is this person?
He, my lord, he was the chairman. Chairman. He has not exhibited the exhibit, all the exhibit, A, B, C, D. I have gone through the affidavit, my lord.
Who has introduced these exhibits?
Nobody, my lord. Nobody has introduced, because it's not reflected either in the order sheet nor in the affidavit filed by them. That was not on record, my lord.
But usually exhibits, documentary or material, whatever,
My lord.
is reflected, in the evidence of the witnesses.
Your lordship.
Where the court will record, so has produced exhibit so and so.
My lord.
This is not.
It's not there. It's not there.
Where did this information come?
I don't know, my lord, because it's only reflected in the judgment and order, my lord.
Judgment.
My lord, as far as because when the cross-examination, normally what happened, my lord, evidence is filed by way of affidavit. On the date of a cross-examination, that time the evidence, the exhibits are introduced, my lord. That has not been done, my lord. That I'll bring to your lordship notice, my lord. This, even in the affidavit, evidence in affidavit also, there's no reference as such, my lord.
Yes.
To all this exhibit, All these 4 exhibit A to D, my lord. There's no reference as such. Only one exhibit which has been exhibited by the OP number 2, my lord. So the second witness which was produced by them, my lord, by the appellant, she, my lord, she is the secretary of the bank, my lord. She has exhibited, my lord, will come at page 196.
This is exhibit A to D, no?
A to D, my lord. A to D.
Page 193.
No, 196, if your lordship kindly see 196.
(196).
196, the paper book, my lord. As per 196, my lord. As per the pagination.
Para?
Paper book. Para 12, my lord.
Para 12.
There's only
I see that the said cottage.
I say that the said cottage Assam type house were totally rotten, dilapidated, and falling apart, which were described by the observed party number 1, collector East Castle, Shillong, as under. On spot inspection appears so and so and so, my lord. So letter number so and so issued by the collector. This is the letter which has been issued by the collector, my lord. Exhibited as paper mark OPEX 1, OPEX 1, my lord.
Yes.
That letter, my lord, will find at a type copy at page 198.
This one.
My lord, this letter does not find place even in the.
This one.
My lord,
This witness is this
she's the secretary, my lord.
OPW 2.
OPW 2, my lord.
Then the earlier one.
Please,
that chairman?
OPW 1. OPW 1, my lord. The chairman is OPW 1, my lord. That your lordship will find at page 187.
Come again. You have referred to para 12.
Para 12, my lord.
What does it say? I mean, what is your contention on this?
The contention of this, my lord, paragraph 12, my lord. I say that said cottage Assam type house were totally rotten, dilapidated, and falling apart, which were described by the opposite party number 1, that is collector Shillong,
Yes.
as under quote. On spot inspection, it appears that the plot described by the bank is part and parcel of plot number 5 belonging to Sri Bajoria, Police Bazaar, Shillong. This portion of the plot is lying vacant, and there is only 2 small dilapidated cottages, which is an eyesore in the area. As such, since this portion is lying uncared by the present owner, it is felt that the same can be resumed for the purpose of Shillong Cooperative Bank, unquote. So the letter has been mentioned. Letter number so and so and so issued by the collector, addressed to the Deputy Secretary, Revenue Department, Government of Meghalaya, exhibited as paper mark OPEX 1, my lord. This is the only document which has been exhibited by the appellant, my lord. But interestingly, my lord, this does not find place in the list of the exhibit and the paper mark, my lord. Your lordship will come to page 262, my lord, again, whereby the court has discussed. My lord will see 264, my lord. 264, my lord.
Yes.
The claimant exhibited the following documents: 1, 2, 3, 4, 5, 6, 7, my lord. 1 to 5 are exhibit, paper mark 6 and 7 are paper mark 1 and 2. This has been exhibited by me, my lord.
Yes.
Opposite party number 2 exhibited the following document: exhibit A, B, C, and D, my lord.
Yes.
This particular document, which has been exhibited through the secretary, does not find place even in the judgment, my lord. This is because this is the judgment, my lord, 264. So, my lord, will kindly see that if your lordship kindly come to page 200. Page 200 in the paper book, madam. This is the cross-examination.
Yes. Of OPW1.
PW1, OPW1, madam. OPW1. Like I've stated earlier, my lord, I have gone through the evidence on affidavit, my lord. I have not found any, except for that letter, my lord, which was exhibited by the OPW2, my lord, in her evidence, my lord, by way of affidavit. As far as the chairman is concerned, the OPW number 1, the entire evidence, my lord, there's no reference to all this exhibit, my lord, A to D. They have not either enclosed the documents, nor the documents has been exhibited, my lord. In as far as the normally, my lord, what happens is that if I'm relying on any documents, they cannot take me by surprise also, my lord. I was not aware of it only when because my entire written argument was based on my pleadings, evidence, and documents, my lord. In as far as OPW 1 is concerned, in his evidence, there's no mention of even one of the exhibit, my lord. That should have come by way of evidence, my lord. So the cross-examination, at the time of cross-examination, my lord, when your lordship will come to page 200, I have filed my deposition on oath. Page 200, my lord.
Yes.
I have filed my deposition on oath by way of an affidavit on 18/8/2017. The signature on the deposition are my signature. I have stated in paragraph 9 of my deposition that I, along with the Deputy Commissioner, conducted spot inspection of the plot number 5 belonging to Sri Bujoria, situated at Police Bazaar, Shillong, which is lying vacant, and therefore a report was prepared by the Deputy Commissioner on 14 May 1985. The report was communicated to the Deputy Secretary, Revenue Department, Government of Meghalaya. Paper mark 1 is the letter dated 14/5/1995, issued by the Deputy Commissioner, addressed to the Deputy Secretary, Revenue, with regard to the plot where there was too dilapidated Assam house, which was recommended for resumption. This is the only paper mark 1, that is the letter, which I've shown earlier. That is the only thing which has been exhibited by the appellant.
Yes.
Further cross-examination, I'll just read because it's not so long. I was born and brought up in Shillong, and I am
okay.
page 202. This is the further cross-examination, continuation of cross-examination.
Why it's noted OPW2?
I don't know.
Yes, please continue.
Well, I was born and brought up in Shillong, and I am permanent resident of Shillong. The Shillong Cooperative Urban Bank is not under occupation of the entire building. This is cross-examination. Some portion of the building has been rented out to various shops for commercial purpose. The bank is occupying the first and the second floor of the building. The basement and the ground floor has been rented out for various commercial purposes. The land which has been acquired by the government for the purpose of setting up of the bank is a commercial area in Shillong. In fact, the entire state and in fact of the entire state, and is situated next to the main GS road. I am not aware what was the prevailing market rate at the time of acquisition of the land. It is fact that Police Bazaar being a commercial area, there is scarcity of land, and being a normal area, there is no restriction there is no restricted in sale and purchase of land in normal area. It is fact that Police Bazaar being a commercial area of the state, the value of land is much more higher as compared to any other area in Shillong. Next one, since the government has assessed the compensation, we paid the compensation as per the assessment of the government. I am not aware on what basis the government has assessed the land. It is a fact that the compensation which has been paid to the claimant is as per the government rate. My lord, this, as I've indicated earlier, that I was paid 80 rupees a square feet, my lord. So this fact has been corroborated by the witness of the appellant itself, that the award which has been given to me at that point of time is not a market value, but it is a government rate, my lord.
Okay.
So this fact also has been corroborated by their own witness, my lord, that the money paid to me is as per the government valuation, not as per the market rate, my lord.
That is para.
It's para 10, my lord. 10, 11. I'll read it again, my lord. Yes. Since the government has assessed the compensation, we pay the compensation as per the assessment of the government. I am not aware on what basis the government has assessed the land. Paragraph 11. It is a fact that the compensation which has been paid to the claimant is as per the government rate, my lord.
Okay.
He goes on to say, I understand the distinction between the government rate and the market rate, my lord. So the witness is well aware of the fact what is the market rate and what is the government rate, my lord. And he goes on to say also that, my lord, in the foregoing paragraph, that the compensation which has been paid to the claimant is as per the government rate, not market rate, my lord. So, my lord, if your lord, I have gone through the cross-examination also, my lord. Here also, my lord, he is referring only to my exhibit, my lord. Nowhere like there has, since the exhibit which has been brought forward by the appellant has not been exhibited. So there's not even a whisper, even at the time of first examination, whereby the exhibit would have been introduced by the appellant, my lord. So in my respectful submission, my lord, the reliance which has been placed by the appellant in as far as the computation of the market value is concerned, on the basis of exhibit A to D, my lord, cannot be taken into consideration, my lord, because nobody has exhibited those exhibits, my lord. Never introduced. It was not there even in the evidence which has been placed by the appellant, my lord. So those exhibit cannot be taken into consideration, my lord. So, my lord, in as far as the award which has been given by the special officer, that is a rate of rupees 800 per square feet, my lord, as I've stated earlier, has been given on the basis of sale deed which has been exhibited by me, which is of 1991. Why it was done so, my lord? Because the collector has taken into consideration the notice under section 4 of 23/12/1991. Based on that, computation was that of 91, my lord. As I've indicated earlier, my lord, all this earlier notification which was published by the collector has culminated to the notification of 1993, my lord. So there is a gap of 2 years, my lord. So in that aspect, my lord, I would say that even the rate which is of 800 rupees, my lord, is below the market value, my lord. Because why I'm saying so, my lord, because the consideration was taken of 1991, whereas the notification is of 1993. So 2 years difference, my lord, that would make a lot of difference, my lord, in as far as the competition.
But you see, without evidence,
my lord, that's true, my lord.
Nothing can be.
That's true, my lord.
Nothing can be ascertained.
That cannot be ascertained, but my lord, I think this honorable court has the power to take into consideration that the notification which was taken under consideration for
see, that assumption can be made.
My lord.
But it would be hypothetical.
Hypothetically, my lord.
Nothing. You see, and in this kind of cases,
my lord,
when the essence is the the market rate,
Your Lordship.
which has to be taken into consideration as far as valuation is concerned.
My lord. So, my lord, they have placed reliance. What they are saying is that the award which has been given to me, it's 100 times more than the initial award of 80 rupees, my lord. So 80 rupees, they are saying that is the just compensation, my lord. In my respectful submission, my lord, as your lordship has said, hypothetically we can say that 2 years of a gap of 91 and 93, 800 rupees, my lord. 800 rupee in my respectful submission is still low, but taking into consideration that no evidence has been put forward by me to arrive at a higher price, my lord, 800 rupees is just and proper in my respectful submission, my lord. So the ground which has been taken by them, that the learned court below or the special judicial officer should have taken into consideration in computing the rate at that point of time, should have been under section 4, first under section 4 notification of 1987, my lord. That, my lord, I would like to reiterate, my lord, that notification have been superseded by the notification of 1993, my lord. So that cannot be taken into consideration. Second aspect, my lord, the sale deed which they are placing reliance is not even, it's reflected as exhibit in as far as the judgment is concerned, but nobody my lord, has introduced them before the court, nor it was exhibited as documents in the evidence which has been filed by the appellant, my lord. So, my lord, even the ground 3 which they have taken, my lord, it's totally irrelevant, my lord, in my respectful submission, my lord. My lord,
How much longer will you take?
I'll take, because there are only 2 more grounds, my lord, which I'll have to,
So we'll continue next date.
my lord.
One week.
Your lordship.
Heard Mr. El Kriam, the Red Counsel for the respondent number 2. Respondent number 8. Respondent number 2. Hearing is not concluded and will continue on the next date. What more, collector?
Lordship, I am here. I'll make the submission. Let them.
He's a pro forma respondent.
Only a pro forma respondent.
Just a facilitating agency, my lord.
This is matter after 1 week for further hearing.
My lord. Okay.
The pin. Wow. I'm done, sure. Oh, but you can see. You miss it, page. Item number 5.
Lordship, I pray for some accommodation on this matter, Lordship. As
Why?
Lordship, conducting counsel is in the other court, Lordship. Son is legs. Just 1 week, Lordship.
You see, I had stopped short as far as the other case is concerned, thinking that this matter would be taken up.
Just 1 week, Lordship. Taken up next week.
You could have continued with the other. Same, that a counsel for the petitioner has sought for accommodation on grounds of personal difficulties. Accordingly, as prayed for, this is matter of the 3 weeks.
Obliged, Lordship.